to state that our organization has matters of public concern with the board's adoption back in June of the additional language added to the guidance document that we feel places burdensome and unnecessary restrictions on on-site soil evaluators, OSEs. That is more restrictive than the actual exemption to the practice of engineering as written in 541400 of the code by the General Assembly. These new restrictions that were included in the revised guidance document inhibit the ability of OSEs to be able to perform their services allowed under the exemption for their clients, as well as provide the necessary sewage system design work required by the Virginia Department of Health for permit approval. It would appear to us that the revised guidance document attempts to circumvent the intent of the General Assembly when they passed the statute creating the exemption to the practice of engineering in the first place. I would appreciate your consideration of our objection and understand how these changes created a tremendous detrimental impact on many of our members. That is why the BAA-OSE would like the board to note our objection and reconsider the added language to the guidance document that we feel is in direct conflict with the actual statute as written in the code. Sincerely, Bob Savage, President of the Association of On-Site Soil Evaluators. Our next public comment is from Mr. Jim Slusser, and he has a handout for the section members. I know you're familiar with our light box. When the green light comes on, we have 5 minutes. The yellow light's your warning light. When the red light comes on, we ask that you stop. However, if the section has questions with the chair's prerogative, they may address them with the executive. Are you ready, sir?
Yes, ma'am. Chairman, members of the board, thank you for giving us the opportunity to speak today. I'd like to start off, I know my time's limited, with a quote. So this isn't about competition or turf. That was a quote from the National Society of Professional Engineers, one Mr. Robert Smith and Bernard Burson in 2013, when they were discussing matters about the unlicensed encroachment of the practice of engineering. I thought we were well established and beyond these encroachments between what engineers are authorized to do by statute and what OSEs can do by statute. And I think what this comes down to, at least in my professional opinion, is we have an overreach. We fully respect an engineer's ability to design systems above and beyond that what an OSE can. But at the same token, while we're trying to promote and grow our own practice, it becomes quite burdensome to continually fend off attacks of our own practice, which by statute we're authorized to do. So I originally was working on a flow sheet last night and said, if, then, how's this go? And I guess it boils down to, if as an OSE we're exempt from the practice of engineering, we are indeed exempt from this board's requirements. There should be no say, there should be nothing to argue here. And what I just witnessed this board do, and we brought this up before with Mr. Johnson, Ms. Langletti, the guidance document does have what I think is clear language. It doesn't appear to be ambiguous. There's statutory construction that we don't have to get into. But if you look at the syntax and then follow the intent of the General Assembly, it's quite clear what we're authorized to do and what we're not authorized to do. And my own take of it is, while I respect the board's action, just for a moment, look at the handout that I provided this morning and read it. There's two issues here that I bring up. One is under the exemption we possess through this board, Title 54.1, Chapter 4, where you define what residential wastewater is. The other definition, the first, is what's listed under the authority that this board granted me. 54.1, 402A11, I'm allowed to design, as an OSE, I'm allowed to design conventional or alternative systems under the authority of Title 32.1, Chapter 6. And in essence, what this guidance document, as with the modification, just did, you're now telling me, per your document, that the engineers apparently own calculations to determine wastewater characterizations or to certify that the wastewater is of residential strength and shall only be done by a licensed PE. That is absolutely contrast. It's adverse to what the code calls for and what's expected and required of our ability and duty to certify our work. I mean, we're done. There's nothing an OSC can do. If you're going to force me to hire an engineer to certify something, again, go back to your definitions. I underlined it for you. Virginia Department of Health regs, quote, and having no other toxic, hazardous, or constituents routinely found in residential wastewater flows. Title 54.1, having no other toxic, hazardous constituents. We derive the ability to draft a characterization from the same resource. It takes the same time. I'm not convinced this is about protecting public health or exercising the police powers of the state. This is, again, it's about turf. And what saddens me about this is prior to this, we practice within our limits. But when we feel it is above ours, we do contact the PD. I have gotten characterizations prior to this guidance document being revised. With the onset of this, something that was a routine $150, $200 evaluation for them to certify the waste stream, we have now gone as high as $1,000. Which one of you engineers in here is worth $800 or $900 an hour? I don't know if anyone in here charges that. Maybe it's none of my business. But this is a direct consequence of what just happened. And so me being a consumer of that service, I don't see this as protecting the police power. This is about turf. And it's about turf where engineers are now manipulating the system and capitalizing on what we hold and we practice and we have been practicing. If I may continue?
Not very much longer, right?
No, ma'am. All right. I just want to cut straight to my objection. And I can get this out in a minute. So thank you for the extension. Well, I don't presume to know that this board erred in rendering their opinion of the revised guidance document. However, while I'm not an attorney, I do contest the revision as published on June 3rd for the following reasons. Reason 1, it clearly appears the board has rendered an opinion that is adverse to present statutory language and authority. Reason 2, in ignoring the plain English reading, it appears this board has created an erroneous interpretation of statute. Reason 3, those charged with its enforcement cannot be permitted to override the statute's clear meaning. Reason 4, it appears this board has misconstrued a statute by singling out a particular term or phrase. Reason 5, in failing to consider common English grammar and syntax with the use of comma and or the disjunctive or, this board has now created an addition to what was not specified in statute as far as determining the wastewater strength. Reason 6, we suspect this arbitrary and capricious interpretation appears to be a clear abuse of delegated discretion by statute. Reason 7, it is equally well established, however, that if the language of a statute is clear and unambiguous, a regulatory interpretation by the department that is in conflict with the plain language of the statute cannot be sustained. Reason 8, as stated by this board, further calculations to determine wastewater characterizations or to certify that the wastewater is of residential strength appears to be inconsistent and in conflict with the exemption provided in 54.1402A11, which states, quote, that conventional and alternative on-site sewage systems receiving residential wastewater under the authority of Chapter 6, Title 32.1, as designed by a licensed on-site soil developer, end quote. And final, but item number 9, reason 9, Chapter 6, Title 31 explicitly states, evaluations and designs included with such submissions shall be certified as complying with the board's regulations. The guidance document interpretation appears to restrain the ability of an OSC to practice within their statutory exemption as identified in 54.1402A11. The unintended consequence of this newly adopted guidance document, as now, a licensed OSE would be limited to basically designing a quote, Type 1 system under the Title 32.1. The Supreme Court of Virginia has held amendments of statutes can only be made by legislature and not courts or administrative officers charged with their enforcement. In closing, I didn't come here to argue law or its effects. That's not my responsibility or purpose. But I did come to try to educate this board and help them understand the ramifications of their actions. Thank you for the additional time. If there are any questions, I'd be glad to answer from our perspective.
Mr. Foster,
Yes, ma'am.
do you have a copy of those 9 reasons that you just outlined?
I could email that to you.
Okay, great, thank you.
Thank you, ma'am.
Next for public comment, we have Mr. Bob Marshall.
Good morning.
I know you know, but just for the record, the green light comes on in 5 minutes, the yellow light is your warning light, and the red light, we ask that you stop, and it's the chair's prerogative to have a few more comments after that. Okay, so when the green light comes on,
My name is Bob Marshall, and I'm AOSC. I'm going to try to be as brief as possible, and I think where I'm going to try to go is to help you understand that we respect the board's desire to clean up the existing statutory parameters imposed by the code and by the General Assembly. I think that's your prerogative, and we understand that this was your intent in beginning this undertaking. On the other hand, I find what we have here is a document that's significantly altered from past and previous documents. And in each iteration, we seem to be getting less and less identification of who we are, beginning with the substitution or the removal of the language about requiring a seal and a stamp. Some of you are new to the board, but some of you have been here already. And it seemed a trifling matter at the time that, you're not required to have a seal under your board. And I think that was an opportunity for this board to say to our board, you need to go into your regulatory review, which we have embarked on and they failed to do, and provide these people a seal if this is a condition of your guidance document. But it was a simple matter to take that out. So now this is out of the guidance document, we move on and we make further changes. We make so many changes. We're in a section A now and a section B. And we are applying conditions to the definitions that do not exist by statutory language. And it's my opinion that in those circumstances, we have no public input, no communication that I'm aware of with our board's director and the members of our board. We could have had a task force and sat down together and ironed out concerns about this. Where were the complaints? Where were the incidences of public health and safety being the public health being impaired? As far as I know, there isn't any. I am personally aware of a complaint, and I just want to read you a little quote that also comes from the National SPE. Let's see here. Give me a second. It's on the liability issues. It says a complaint must never be motivated by personal animosity or an attempt to gain some type of competitive advantage over another party. Such ill-motivated complaints could expose the individual complainant to defamation and antitrust liability claims, which can result in damage awards, fines, and even criminal penalties, not to mention legal fees and court costs. Now, we know this complaint was generated by the largest competitor in this industry, VDH. And I've been before this board to remind you that we have a conflict of interest with VDH by their own hand approving their own work. And nothing has been done about this yet. And so we are either exempt from the practice of engineering, where none of this applies to us, or you need to bring us into this board so that you can regulate these things and we can get people a standard of engineering. Because I believe that's the intent of what you tried to do with this guidance document, is we want an engineering standard out there. And you can get that, but you can't get that by exempting us and allowing VDH to continue to run a bully in the marketplace. And with that, I guess I close my comments.
Thanks. Public comment. Just move on to item 6.
Yes, and you have your handout in front of you, which is